From the Sunshine State, this is Tampa Bay's Tan Talk.
It's time for FLALAW, brought to you by the personal injury attorneys of Paranick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
That's right. We are back with FLALAW live on the radio. Thank you for joining us tonight. This is your live legal call-in talk show. We come to you every Tuesday at 5 o'clock. And of course, this is your opportunity to speak with lawyers from the law firm of Paranick, Caulfield, Averill, Noyes, and also local experts in our community and other various areas of the law, different law firm owners and local attorneys who come on our show every Tuesday to make themselves available to answer questions and also just give you great information about the law on various legal topics. So if this is your first time listening, thank you for joining us. We are happy to have you listening in tonight. This is going to be an awesome show. We do have a great guest with us tonight, but before I introduce who I have with me in the studio, I do want to make sure you have all the ways to continue listening on throughout the next hour, because this is a 1 hour show. So you'll have us until 6 p.m. And so I want to make sure you know of all the ways to continue watching or to come back and listen and watch later. So first and foremost, this is a live legal call-in talk show. So if you have a burning question for myself or my guest host tonight, the number you're going to want to call into is at the WTAN studios at 727-441-3000. So if you're listening to FLALAW live right now on April 14th and you want to get your question answered live over the air, this is the time to call at 727-441-3000. If you're a bit shy and you do not want to hear yourself on the radio and you just want to drop us a question or a comment in the chat, that is not a problem. You can do that too. And you can do that over at Paranick, Caulfield, Averill, and Noyes Injury Lawyers. And that is on our live feed right now on Facebook and also on YouTube. So if you do that, go over to that comment section and I will be able to read those out live over the air. So if we get a comment or a question from you on Facebook or YouTube, we will read those, and if it's for me or my guests, we'll definitely read those out over the air and try to answer those for you, or just point you in the right direction. If it's a topic that we're not discussing at that moment, that's okay. Bring it in, and we will answer the question or try to get you over to somebody that we may know that might do that. So if it's not family law or personal injury, we can still try to point you in the right direction wherever that applies. With that being said, if you don't know how to spell Paranick, it's P-E-R-E-N-I-C-H. Search that in your search bar on Facebook or YouTube, and that'll take you to the live stream. You will see us in the studio tonight with my beautiful co-host, and we're sitting here waiting for you to call in. Also, the good news is that if you don't get to watch the whole show tonight, no worries. We do have this show on podcast. So wherever you consume your podcast, Spotify, iHeartRadio, Apple Podcasts, you name it, we are on there. Just search FLALAW on the radio, follow us, and you will be able to see tonight's show amongst all the other episodes that we have on there. So later on, if you want to watch the show and you maybe left off in the middle and you want to catch up to everything that was said, no worries. Just follow us on wherever you get your podcasts, Apple Podcasts, Spotify, or what have you. FLALAW on the radio is where you'll find us. And then tonight's show will be uploaded very soon. So you'll be able to go back and download it, listen to it at your leisure. So with that being said, and without further ado, I would love to introduce you to my guest tonight. She is no stranger to FLALAW on the radio. She's been with us before, and I'm so happy to have her back. She's always gives us such a great wealth of knowledge and understanding of Florida family law. And we talk about, in the past, we talked about custody and child support and divorce and different things. And so we're doing that again tonight. We know that a lot of people need this information, and they're usually kind of figuring out where to go and what's next. And so this is a good show if you're in that position where maybe you're going through a breakup, or you're not sure and you don't know if divorce is the right answer, and maybe it is or maybe it isn't, and you've got questions, well, this is the show for you. And so before I jump into what we're going to be talking about tonight, I would like to introduce you to my co-host, and I'll let her, of course, tell you a little bit more about her firm and what she does as well. But I know her as a former classmate. We went to the same law school, Stetson University College of Law, and she is the owner of Golden Key Law Group, which is an awesome law firm here locally in Pinellas County. And she is the current president of the Clearwater Bar Association. She has quite the resume, and she's done quite a bit of work in this community, and she's just a great lawyer to know and to have in your contacts. So I will pass it over to her for her to say hello and introduce herself to our audience.
Thank you, Jackie, for having me.
Of course.
And, I'm so happy to be here today to talk about all things family law.
Yes.
And so, I'm the owner of Golden Key Law Group. We've been in Pinellas Park for about 10 years. I think going on 11.
Wow.
And so I have the most complex, unique cases of the office. We have about 4 attorneys, including myself. And so it's just a very fun area. I mean, there's a lot of different implications, crossovers, criminal, business law, real estate, which is my second practice area. And so I have a lot of, wealth of knowledge to share. And if people have questions, feel free to call. I'm here to help.
And that's what we're here for tonight. And we're going to throw a little bit of, pop culture into the conversation every now and then wherever we can. I think we're having a little bit of a technical difficulties. Okay. I'm going to restart our live feed, but we've got divorce is kind of the topic for this evening. It's not always a fun topic when you're going through it, but it is a very common thing that we're starting to see. So we may talk about a little bit of things that are kind of going on in the news and different high-profile, pop culture things that are going on when it comes to divorce and filings, custody issues that we might be seeing here lately in those areas, and kind of talk about how that might apply in Florida, Florida family law, and what that really means for kind of your average everyday person, right? Because what we might see, the Judge Mathises of the world, or Candy Burris, or even Cardi B, who's got this big divorce. She's kind of filed, I think, a bunch of times.
Oh, yeah.
Of divorce. And then, they've got lots of assets, and they're high net worth individuals. That may not be, what you experience on a day-to-day basis. For an average individual person who, is married to someone for years. They share property, assets, children, but maybe not high net worth or not, those sorts of situations. So we're going to kind of talk about that. But let me go ahead and get our live feed started back again and see if we can grab our
I was trying
streaming.
to figure out here how to share it myself.
Yeah, and that way you can share it. And what I encourage folks to do is, if you see the live stream and it's on your feed, then please go ahead and share it as well with anybody that you know, your family, friends, get it going. All right. So with that being said, my first question for you, while we're getting that all squared away, Florida, are we considered a no-fault state as far as divorce? Like, do you have to have a reason in order to be able to file? And what does that actually mean in real life terms?
Yeah, so Florida is considered a no-fault state. We don't have requirements that other states may have, which is, you have to be separated for 1 year,
okay,
go to marital counseling, or do some of those prerequisites. There does not have to be any sort of cause. The only requirement is that one person, usually the person that files, but one person just has to believe that the marriage is irretrievably broken.
Okay.
And what that means is that they believe that their marriage, that they should be divorced, and there's nothing that the court can order or do to fix it, such as marriage
counseling, because I always think about, is there something that happens before the divorce filing like this? I remember when I got my marriage certificate, that was something that was discussed, was marriage counseling. But before a divorce petition is filed, is there any requirement to do anything like that before you get started?
No, there's nothing required. I mean, if there's children involved, there is a requirement that the parties take a co-parenting course and learn how to learn healthy co-parenting mechanisms and the effects on children if there is a bad relation, if people are engaging in behavior that's not healthy. They do talk about the adverse experiences that children can have and how that oftentimes manifests into adulthood.
Right.
So, but as in regards to the marriage itself, that's one of the questions that the judge asks. We call it during the jurisdictional questions to establish whether the court has jurisdiction to issue a final divorce decree. And I've had on a few occasions, actually, where one person would say, no, the marriage is not, I don't believe that it's broken. I think I can fix it. Yeah. But, and it's heartbreaking to see, because even though they may feel that way, so long as the other party wants to continue with the divorce, then
that's all that matters.
Yeah, that's what the judge looks at.
So that's what no fault essentially means in our state. Okay.
And that, and so I've had, funny enough, a few people most recently call and they want to talk about infidelity and spouses stealing or hiding money and some of those things in which it's only relevant in certain circumstances. So in regards to infidelity, the courts typically it's typically not relevant unless marital money is being used.
Oh,
is being used to support that infidelity, and that's where that becomes relevant. And so then the second point of that is it worth it from a cost-benefit analysis? Do you want to spend the money and the time to prove that, to recoup, $200 in a hotel fee? Those are the things that you have to think about.
Interesting.
So that can consider dissipation.
We are definitely not like Georgia, because I don't know if I don't know any of these people, but there was this big TikToker, and I know you've heard about it. Yeah. Who I guess started dating a friend's husband, and then they separated, and she was with him, and so there was a big lawsuit that was filed for alienation of affection or something like that, which we don't have in Florida, right?
No.
And so, but she got this multi-million-dollar verdict, right? Yeah. For basically her stealing her husband away, and she won. And from what I understand, the girl, I can't remember the TikToker's name, was saying that, she's never going to pay that judgment, but apparently the judge has now ordered that she pay a pretty significant sum to this woman. I thought, oh my gosh, that is like a game changer in that state, to be able to sue basically your husband's mistress. I know. So what are your thoughts on that? I know we don't have that here in Florida, but it's interesting, because I taught family law at Stetson, and we reviewed some of the different grounds. Right. And I find it interesting. Yeah. I wonder, maybe the collectability of that kind of thing. I feel like most people just won't be able to pay those judgments.
Well, and that's it, right? It's like you can't get a lot out of nothing.
Yeah, blood from a turnip, or however the phrases go. Right. So I think she was right and strategic to obviously sue the TikToker, because obviously nowadays, content creators, they can have considerable assets. So I could see why she chose to bring that lawsuit.
And 100%. And I think that, and alimony contemplates this, the alimony statute. There's once you've established that there's a need and there's an ability to pay, there's a series of factors that the court has to consider. And, one of them is whether a spouse has given up their career or their aspirations in furtherance of the other spouse and taking care of children. Right. And so,
so that's kind of a way to recoup some damages in a marriage.
So there are some, considerations, and I would think, you wouldn't want to be in a relationship with a cheater, you know, if you had the choice. And so it's like, how do you prove that kind of stuff? That's what I would be interested. Is it text messages? Is it video? Do you get a private investigator?
Right. I would think in the normal every day-to-day sense, it is hard to prove something like that. However, in that unique case that we're talking about in Georgia, it probably was easier because they document their whole lives on TikTok.
Well, that's true.
So it's like the evidence that they needed was put out to the general public to see. So
and then how did they monetize that?
Yeah.
How did they figure out that amount? You know, is that based, because in Florida, when it comes to the money aspect of divorce, it needs to be quantifiable. Yeah. You know, they have, with the reform in 2023, in July of 2023.
You guys got a big reform as well.
A
like
huge
we did.
reform, in a sense.
When I say we, I mean PI attorneys,
Yeah, they brought a lot more formality to the way that alimony is calculated and quantified. So there was previously a lot of discretion given to the judges to come up with those award amounts. And now they have implemented caps on duration, caps on the amount, and done away with permanent alimony. Yeah. And has given us,
that's a big change.
Ways that we can calculate it and ranges in which the court can order. So,
so far, obviously, it's been 2023, so it's somewhat fairly still fresh. Do you feel like it's had a negative impact, or that it's been positive to see those caps and those more formalized, less discretionary changes to the law?
With all things, I think there's pros and cons. I mean, the pros, I would say it gives the attorneys a guideline to advise our client.
Not as much guesswork in it. Yeah.
Right. So we can, once we have the financial information, we can figure out what the net incomes are, can tell our client, look, your cap is 35% of the net difference. And then in regards to the duration, it's basically, the length of marriage. Okay. And depending on the length of marriage, then the duration, the longer you're married, the higher the percentage of alimony you can get. So while it's great for a general guideline, there are going to be those circumstances where a client's like, well, should I wait one more year to get 50
to try to get a
60?
more fairness in it or whatever,
Especially when they're in a challenging situation or abusive situation, they're thinking about, well, I want support for another couple of years. Should I wait? Should I stay in this circumstance? So that's where
it's strategic. Interesting. That's where they have to definitely rely upon you for those kinds of
and so
advice,
then you're making me decide, well, do you stay in this horrible circumstance to get a couple of years?
Don't make me decide when you file for divorce. Yeah,
exactly.
That's very challenging. That's interesting. So obviously, to clarify for our listeners, that we're talking about this TikToker's case, and for the life of me, I can't recall her name, but it was in the news quite a bit because there was a huge verdict that came out of Georgia against her, but we don't have that here. So you can't bring lawsuits. Let's say there is infidelity, like you mentioned. What's the relevance in it? Sometimes in Florida, so those kinds of lawsuits don't exist in terms of suing the mistress, if you will, or the homewrecker for damaging the marriage or causing the marriage to fail. That just doesn't happen here in Florida.
No.
Yeah. So it's interesting because you would think that people, from a principle standpoint, just they want to make this an issue because you're the reason why, and you did this, and this is why our marriage fell apart. But really, it sounds like it doesn't have a whole lot of bearing. No,
there's no punitive damages. Because you're wrong and you've caused me distress, there's no recovery for that. Now, if there is money being spent,
like you said,
then that's dissipation. You're using the marital income for non-marital purposes, and so money can be recouped in that end.
Okay, so like we mentioned kind of in our intro, how for all intents and purposes, some people that haven't been through divorce or don't have any experience with it, they rely upon what they see in the news. These big celebrity divorces. I could just think of like Brad Pitt and Angelina Jolie went on for years. I'm like, oh my gosh, they're still going through a divorce. But is that typical? How long does a divorce really take to get through in Florida, if you will?
Okay, and I get this question a lot, and it's really hard to put a time frame on it, but I like to give clients and prospective clients as many answers as I can give and can provide. So it really just depends on the complexity of the case and the motivation of the parties to resolve the case. So, for instance, what takes quite a bit of time, I would say the two biggest time constraints or the things that take a lot of time are discovery. Yeah. Which in any area of law, discovery takes time. So
and probably a lot of money too. It can cost.
And so in every case, every divorce and typical time-sharing paternity case, we are required to file financial affidavits and mandatory disclosures within 45 days. Yeah. However, as you know, that's just the beginning of the mandatory process. That's just the mandatory process, right? Yeah. There may be additional requests for production, of course, interrogatories. You may want to do depositions. Someone has to go through those documents, and so that's that can take quite a bit of time. The other issue is actually getting into court. Getting a court date, especially the longer the hearing that you need, the more time it takes. So that can
the further out that's going to be.
Right. And you can average maybe it taking the standard 2 months, right? But sometimes longer. I mean, a trial can be 6 months out. Yeah. And so really, it comes down to how much documents, how much are we exchanging to make a decision, and are we fighting in court? Do we need to see a judge? Yeah. And so with those two things come into play, the more that we have to go before the judge and the more documents that we request, because as you know, when you propound documents, they get time to respond. Yeah. Yeah. It
becomes kind of a tit for tat at that point. Yeah. So you requested this, we request that, and then we review it. And then so there's obviously time frames, civil rules of procedure that are going to be built in, in terms of how long they have before they can respond. And then once you get it, that might spark additional discovery.
Exactly. Exactly. Now, the court, they have a goal to resolve these cases. I mean, think about at the 1 year mark, they start getting on us, They're like, okay, attorneys, this case has been sitting. What are you going to do? And I'm like, it's not been sitting. We've been trying to figure this out and that out. And, while the average caseload of a judge, it's about 700 to 800 cases. Wow. They don't see, there's not many that's going and landing before them. Right. Now, I see the judges quite often. I think that I am settling cases. I'd like to think that, but I am in court quite a bit.
Right. Okay, so that obviously gives people good insight in terms of, the general timeline. Obviously, the more complex the issues are, the longer it can take. Yeah. One thing I haven't heard you mention, but I feel like this is something that is also going to have a good impact on the time that it takes, is whether it's contested or not, right?
Oh, 100%.
Could you explain what that means?
Yeah. So a contested, and it could be divorce or paternity case, really that means that the parties are they're not in agreement as to the major aspects that need to be resolved. Sometimes minor aspects, they're not on the same page. Yeah. Right? And so
I can imagine sometimes it can get very minor.
You would 4 to 6 versus 4 to 7. Sometimes you're fighting over an hour. Wow. But so my goal with the contested cases is to resolve as much as we can. Mm-hmm. And so if we've resolved a standard parenting plan, and usually that's what people need. They need some sort of structure and guideline. And what the court will say, what the judge will say is, look, you can put this in a drawer and do your own thing, but if there's a disagreement, you need to pull that parenting plan out, and that's what governs, right? And it's about 14 to 15 pages long. So there are times where we agree to every single provision, but we may not agree to out-of-state travel, for instance, right? Like, one person wants notice and the ability to object. One person just wants to be able to go. Yeah. So my goal is to resolve as much as possible so that we are requesting the least amount of court time that's necessary, and thereby making it more affordable for the client. So, and now uncontested cases, that means that you agree to everything. We just need to reduce it to writing and follow the legalities and formalities. And sometimes it takes 2 months, 3 months, not even.
And those don't need to go before a judge, right?
Well,
just to get your final
divorces
decree.
do.
Okay.
So the divorces have to go before the judge for like a 5-minute hearing.
Just kind of for finality.
Just to establish jurisdiction that the person that filed has been, in the state of Florida for at least 6 months. They live here, that the court has jurisdiction, and that there's no children on the way. I've had that happen and learned that at the final hearing.
That they were pregnant.
Oh, yeah. And that presents issues, too, as to legal.
Now we have a problem.
Oh, yeah, because there's
with
a
paternity,
difference.
Right?
For paternity, because if a child is born to a marriage, there's a presumption that the husband is the legal father.
Yeah.
And so if the husband is not the legal father, excuse me, let me rephrase. If the husband's not the biological father, then you need to deal with the disestablishment of the husband to establish the bio father. And I've dealt with that too.
Back to pop culture. Because again, I mentioned Cardi B in the beginning, but my understanding is that's what happened with Cardi B, where she filed for divorce, was separated from her husband, who's rapper Offset. Then she started dating NFL player Stephon Diggs, and she got pregnant from Stephon Diggs, although still being married to her husband. So that's kind of the situation that would be involved there, right?
100%.
Because legally, I guess, although it's not his child, Offset is technically...
Oh, yeah. So
it's crazy.
And it happens, especially when people are separated.
Yeah.
So the case law, the law has evolved. It's beginning to evolve, but it's still, there still is a presumption that if a child is born to a husband and a wife, that the husband is the legal father.
Wow. Even
though someone else, and we all can have knowledge of that, is the biological father. And so I've had actually a case where the legal father, wanted to push the biological father out and say, no, this is my child.
Wow. Even knowing that
even though he knows that the other father was the biological father.
Wow.
So I filed a paternity case, and I outlined how involved the biological father is, because there was a Supreme Court case that kind of changed that talks about whether the biological father has demonstrated substantial concern, meaning that they were around and involved in the and financially provided and spent the time with the child. And I did not get an opportunity to argue that, but because when the husband reviewed that petition, he filed for divorce. He filed for divorce and dropped his position.
I gotcha. Well, I can say didn't see that coming.
Yeah, it's very interesting.
We do have a question in our comments. It says, they say it's not contested and you need to reduce to writing, but that writing is taking time or someone is delaying. What point would you consider is contested?
Okay, I get what you're saying. So what you're basically saying is that your spouse or the spouse is informing you that we have an agreement, but there's what should be signed the document, that's not happening.
That's what it sounds like, yeah.
Sometimes you have to put pressure on that. And really what I like to do is a dual track, right? And so it's in a sense of, I would love to work this out. I'd love to resolve this, but we need to keep the process going. And so with that, you can do...
so it's like we're willing to do this uncontested, but because you're taking too long,
we're
also going to keep
with the
going.
formalities.
I got you.
Correct. So, what you can do is there's a mediation requirement in paternity cases, divorce cases. And so if he does agree, well, let's go to mediation.
Right.
Because then that's your opportunity to sign.
Right.
Or that's your opportunity to deal in a space that's created for that with maybe the one or two provisions that's hanging it up, that's causing that's bottlenecking disagreement. Because oftentimes there is a dynamic where, one person tends to be more outspoken or more, pushing it more further along than the other. And so mediation is a formal place with a neutral mediator whose goal is to obtain an agreement.
Right.
And or you get 80 to 90% of it agreed to, and then you can have an hour hearing on that one or two provisions.
Small issues, yeah.
Right. And so my recommendation would be to continue with the formalities, and you'd be surprised, like, right now I am scheduled for about 5 trials. Do I expect all of them to go? I hope not. But sometimes, even as attorneys, we have to move the cases along.
Right.
And you'd be surprised how many cases are settled at the courthouse steps or in the morning of court or the night before. One of them more recently was settled at 3 o'clock in the morning the night before trial.
Right.
And so sometimes you just have to put that pressure.
Right, exactly. All right, so that is the person, McKinley says, like the mediation idea, you walk out and don't sign, I'm calling it contested.
Right, that's where it shifts.
Yeah.
That's exactly where it shifts.
McKinley, appreciate that. Yeah. You have to have both tracks kind of going simultaneously.
Both tracks. And there are times where we actually test whether it's contested or uncontested, right? So before filing the case, we'll send over a marital settlement agreement or we'll send over a proposed parenting plan and give them some time to respond. If they don't respond, then we're assuming that you don't agree.
Absolutely. That makes perfect sense. So then what about people because there are some ramifications in the personal injury world. If we file a lawsuit, we're assuming this thing is going full speed ahead. We don't typically back out or withdraw or dismiss unless the case has settled. So I heard recently, I don't know if people are familiar with TV Judge Mathis, his wife like a year ago filed for divorce after being married for like 40 years. But then recently I just saw she dismissed or withdrew the petition. I feel like that's more common in the family law sector. And does it have any implications, or you can just say, you know what, I changed my mind? Is that kind of how that works? So,
yeah.
Okay.
And so definitely, I mean, people can dismiss their cases. Which oftentimes that's why we file counter petitions, because I actually learned the hard way, where we had temporary parenting plan. We were mid-case. I mean, property were being divided. And the other spouse, to get an advantage, to try to get an advantage on the timesharing, dismissed, and then stopped abiding by the agreement.
Oh, my goodness.
And so we had to refile. We refiled like 2 days later. Yeah. So now you'll see, we automatically file counter petitions. And, it could be that, there's filing fees and stuff associated with that. But just to preserve our clients' rights to move forward with the divorce, even if the other person dismisses.
Exactly. Okay, that makes sense then. So just because one spouse says, I changed my mind, and the other spouse does not need to necessarily feel that way. Yeah.
And you can put cases in abatement, too. So I've had those instances where people are like, oh, I want to work it out. I want to put things on hold. And we file something formally with the court and say, look, they're going to marriage counseling.
Okay.
We need to slow down on these deadlines and give them a chance to work it out.
Judge, don't fast track us to trial right now.
Yes,
I got you.
Let's, public policy. We try to keep people together. So if that's what they want to do. So if somebody says, I don't think my marriage is irretrievably broken and I want to go to counseling, the judge would ask the other party,
are they open to that?
Are they open to that?
Interesting.
Yeah.
Well, let's shift gears then a little bit. It's come up as far as time sharing. You've mentioned that a few times here. So let's talk about that a little bit. I think historically I've always called it custody, but I don't think that's necessarily what it's called in Florida, or at least not anymore. So let's talk about what Florida calls time sharing and what does that actually mean for parents.
Okay. So, custody is an archaic term. Yeah. We don't use that term anymore. What we really, the two biggest areas is really parental responsibility, right? That's decision-making authority. And there is a presumption that it should be shared. Typically it's shared. If somebody wants to have sole decision-making authority, they would have to specifically plead for that and then prove as that it's detrimental to the child for the other parent to make decisions. And there's also times where people can ask for ultimate decision-making authority, which means I want to be the tiebreaker.
Yeah.
And really, you just have to set forth that here's the reasons why it's in the best interest of the child, and it can even be to this specific area, like in regards to healthcare, in regards to, school issues, and so that's parental responsibility. Time sharing is really the schedule. Right, between both parents. Right. And in 2023, that's another change that was made. In July of 2023, the statutes legislature established that there is a presumption that both parents should have equal time with the child.
Okay, so is that something that was new?
That's new.
Oh, okay. Now, I just assumed that's what it was supposed to be.
Well, look, it depends, right? So I find that certain counties, they were already doing that. Like, in Hillsborough, they were already doing that for the most part. Now, in Pinellas, they weren't.
Okay.
But all that means, it's people misconstrue this concept a lot because they come in and say, and, both mothers, fathers, it doesn't matter, that the statute change, it says that 50-50 is what it is. That's the law, and it's really just the starting point, right? So that's where the needle starts. It starts there, and then there's a series of factors, about 20 of them, that the court considers. There's no super factor, but there's 20 of them, and that can move the needle to either direction, and the standard is preponderance of the evidence. Okay. So, and what that means is, 51%, sure. Right? It's not like the criminal beyond a reasonable doubt, 99, but it's so there are factors that can be argued to move that needle, but you do still have some judges who are more willing to do, who's going to most likely do 50-50 every time, and more times than not. And then some who are like, if you give me a reason.
Let's hear all the factors. Yeah.
But it all comes down to what is in the best interest of the child, and there has to be specific findings as to that.
Okay. Now, what we have seen, I think, in a lot, again, because most people don't, unless they have direct personal knowledge of, someone close to them or themselves going through this, they don't really have an idea of what is going on besides what they see on TV. So I see in the news a lot where if you're like Real Housewives fans, you see like Kim Zolciak and Drew Sidor, different people that they're temporarily losing custody, where their kids are temporarily taken from them, or their kids are temporarily with dad. And you're like, what is going on? Is that common to have temporary shifts within the time sharing, and is there something bad about that? Because to me it feels like, oh, they must have done something that made them lose their kids. But is that necessarily true? Could it be a lot less salacious than that? Because my mind automatically goes to, oh, they're on drugs or something's bad. They don't have a proper living arrangement or something, or they can't afford to pay for their kids, and so that's just my mind goes to that. But it seems like it could be something, there's a factor that has now shifted that makes it better for them to be with the other parent.
Correct. Yeah, it does not have to be salacious. I mean, and we can talk about the salacious stuff. If someone's dealing with like a drug issue or alcohol issue, or
gambling,
or there's some instability there, then they may need some time to get on their feet. And family law court is a court of rehabilitation. We practice rehabilitative, therapeutic law. I call it rehabilitative, but it's therapeutic law, which means if I have a client that has those struggles, from consultation time, are you seeing a therapist? Have you been evaluated? Are you on medication? Are you I try to do some problem solving. And, the law doesn't require for you to be a perfect parent. Right. It just requires for you to have the capacity to be informed about the child, be involved in with the child, and to be able to make healthy decisions for the child. And if there's something that's preventing that, then we need to fix it now so that when we get to a final hearing or after a certain amount of months, we can show the judge that, hey, there is a demonstrated change here.
Right.
And here's how we can continue. Here's our plan to continue to maintain this change. And show that the parent is, dedicated to maintaining that.
Right.
But it can be even in a sense of just testing it out.
Yeah.
Right? So if a parent has been the primary parent, and a person can file for paternity at any time. I mean, I've had cases where the child's 10, 12, 15, it doesn't matter, and they don't have that relationship with the other parent, or they're trying to build that. We'll put in place temporary agreements, so we may need to scale it up or scale it back, and it's really just a trial period.
Right, I see.
And, while it could be unfortunate because the child is in the middle of the test, we hope that the test goes well. Or we can see the things that need more parameters. Like, I had this one case, things were very rough, co-parenting relationship, very, very rough, They had a temporary agreement for 6 months, and now they are getting along really, really well. But we learned that, okay, there are some hang-ups around winter time sharing, winter break, Thanksgiving break, school breaks.
Yeah.
And so now we know we need to spell that out to a T and anticipate what we can anticipate. But the parenting plan is already extensive, so we can't do that for every single provision. So that's how temporary parenting plans are helpful.
So then what are some of the common factors that you find judges actually consider when they're trying to decide who a child will actually reside with or spend most of their time with?
Okay. And so what I will talk about is the things that aren't obvious, right?
Yeah.
Not the no-brainers where there's domestic violence and alcohol.
Sure.
Let's talk about some of the nuanced issues. Really, distance between the homes.
Okay.
Right? How far is the child having to travel to school, to mom's house, to dad's house, to both mom, extracurricular activities, work schedules. Is there going to be a third person that's taking on the bulk of the parental responsibilities, or can the parent themselves handle that?
Yeah, or like if one parent works the night shift or
right,
something.
exactly. It can be, should there be a school parent? And so that, or who's doing, is the other, are both parents both involved with the medical decisions, or taking them, or they got the order to take their, the script, or are they filling the scripts? It's really just like the capacity to be a school parent versus a Disney parent. Yeah. They're little, and that's what we call them.
Explain what you mean by the Disney parent.
Well, that's the
fairy
fun
tales
parent,
and LALAW,
Well, that's the weekend
stuff.
school break parent. Are you that parent, or are you the parent dealing with the day-to-day, which we know we get off of work at 5, right? Pick our kid up. There's 5:30, 6, and then the routine, right? Are you setting a routine? That's actually one of the factors there. Do you have the ability to set a routine for the child that's gonna be healthy and not result in grades? Are you doing homework? So those are the little nuanced matters, right? Or factors rather, that may or may not shift the needle.
I feel like when I was in law school and I was studying, I took family law, that the best interest of the child seemed to be like one of the main things. Is that still the way the courts look at it, or is that not necessarily the major issue?
That is the major issue. It's always in the consideration. Yeah. And so these things that we're talking about, routine, bedtime, doctor's appointment, school,
it's
distance,
not about what works for mom or dad.
No. All of these are factors under that determines the best interest of the child.
Right.
Yeah.
So we've only got about 10 minutes left, and I know this is a really big topic, so I want to make sure we spend some time on this. So let's shift a little bit to child support, right?
Okay, yeah.
Because people get this wrong, I think, a lot of times in terms of trying to figure out what it means and how it's calculated and how much they feel should be paid or shouldn't be paid. Right. So let's just talk about it. How is child support calculated in Florida?
Okay. So child support is calculated pursuant to guidelines. And just the skinny on the guidelines, basically the court takes into consideration both parties' income. So that's gross income minus allowable deductions. And then the health insurance costs for the child, the child care, daycare costs for the child,
Sounds
if
like
any.
we're filing taxes, which are due tomorrow.
Right?
My goodness. Go ahead.
And then there's the tax implications, right? Like who's claiming the child. And those, and then the overnight, right? The amount of time that you're spending with the child.
Gotcha.
And so all of those things, we put that into our calculator.
I was going to say there's essentially a calculator, right?
And it gives us a number.
Gotcha.
And that's that's what's called the child support guidelines, and that is required to be filed.
Gotcha.
Yeah.
All right. So there's not like this thing where you're calculating it on your own. It is pretty much laid out for you by statute.
It's laid out by statute with formulas.
Gotcha.
And so the family law attorneys that practice family law day in and day out, we all have different software. We have software that we use that we run those calculations. Now things can get nuanced, right? Such as like deductions.
Yeah, sure.
Things can get nuanced if you have other children and you want to receive credit for that. And so there are some, things that may come into dispute when it relates to child support.
I gotcha.
And then
That
there's a
makes
different standard after a parent exercises 72 overnights, and that's where you start getting credit under the gross up method. So it's that's where they start getting the additional credit that can reduce their child support. And so that's where there's this misconception that if I get 50-50, I'm not going to pay child support, and that's not the way that it works. It really just depends on the difference between the incomes and the expenses for the child. And so if someone out-earns someone else, like the other parent 3 times, and they're paying, and depending on who's paying the expense, they can be exercising equal time, but that parent may still have to pay.
Now, is child support something that we talked about, sitting down and making agreements, things that are uncontested, but is child support one of those things where you can just say, we'll waive that, I won't pursue it, and this is not an issue that we're going to fight about? Or is it not allowed when it comes to child support?
Yeah, no, child support, you cannot waive child support.
Okay.
Child support is the right of the child. In fact, it's hard to establish time sharing. You can't establish time sharing oftentimes without, child support
That makes
being
sense.
hand in hand. Now, what I would say is, while it cannot be waived, there are a few circumstances where you can ask for a deviation
From the guidelines.
Okay. But that has to be specifically pled and approved by the judge. So there have been times where myself and opposing counsel and our clients agree.
You wanted it.
Yeah, agree, and it's in a agreement. It's in a marital settlement agreement or a proposed final judgment, and the judge, he says no, she says no, or they want some clarification as to why you're asking for it, and so you have to put
Judge, because we agreed. No.
They're like, that's nice, but it belongs to the child.
Right.
So then you have to explain.
I understand. And that role, then the judge is kind of standing in the shoes of, advocating for the child.
The local parente, the parent, like the judicial parent in a sense. Yeah.
So then when it comes to the agreement, when you say you can deviate, it can be a deviate upward or downward?
Yes,
okay.
There can be a deviation upward or downward, and to modify, and that's why it's important to have on the record or the final judgment what the parties make, right? And so that if you want to modify, that information is there, which the standard is if the child support would change. If the change will result in a difference of $50 or 15%, that's the standard, which isn't, very high.
Right. So you kind of nicely segued into my next question, which is, what if there's significant income changes, either upward or downward, where someone's now making a lot more or a lot less? What happens then with the child support?
Yep, you can file a petition to modify.
Okay.
And that's the standard. $50, if it's going to result in a change of $50 or 15%, then the court can modify the child support.
Okay.
And another thing, the Department of Revenue, people are like, well, we're getting along well. Why are you putting me on child support? Well, they require, if a person's asking for public assistance.
That's what I know, yeah. So food stamps or any WIC or anything like that, then they have to put the other
parent on support, on child support, to be able to recoup the expenses.
All right, so my next and maybe final question is, what happens if there's a change? So we talk about changes in income, but what if there's a change in the living arrangement where now at one point when I was paying child support, the child was living full-time with mom or full-time with dad. But now I'm still paying child support and the child now lives full-time with me because of circumstances. What can I do now about that?
You can modify.
Okay.
You can modify because the outcome is still going to result in the change of $50 or 15%, because now the overnights, you're going to get the
credit that you're talking about.
Exactly. Okay. The parent will get the credit for the overnight time sharing shifting to them being the majority parent.
And so how does that work? Because I know you said sometimes hearings can be set out. So if a parent has been, let's say they've been doing this for a while, and they just filed their motion for modification, can they go backwards and say, I've had her for 6 months already, and it took me 2 months just to get a hearing. It's now been 8 months. What can I get my child support money back from those past couple months?
And I've argued this.
Yeah.
I've argued this. So you have to, the case law says that it's from the date of the filing, right? So it can relate back. Once you've filed, you've preserved that, request for relief from modification from the date of filing to whenever the case is resolved, but not before that. Yeah. And so I would advise, recommend
do
people
it right away.
Do it right away. Yes. File something, even if you do it pro se.
Oh my gosh, yeah. That's quite interesting. And I wish we have to have you back because we have so many more questions we could talk about with high profile divorce, high conflict divorce, social media.
Oh man.
But we don't have time to get into that tonight. I hope.
And I have cross-examined on IG posts and Facebook. Yes. We are looking.
Oh, and TikTok, I'm sure.
Yeah, we are looking.
So we'll definitely have to have you back to talk about some of those things and how they can impact your Florida family law case. But with our last few minutes, I just want you to give everybody your info, how to find you and how to reach you, whether it be your phone or socials.
Yeah, so like I said, we're located in Pinellas Park. We are on Facebook and Instagram. Golden Key Law Group is the firm name. Our phone number is 727-317-4738. Reach out to us. We're here to help.
Perfect. It has been a pleasure having you. I always love having you on the show. So if you guys have family law needs, then of course, certainly reach out to Charis. She can be a wealth of knowledge and be able to assist you through that process. And of course, all things personal injury, you can give us a call at 727-796-8282 at Parent Caulfield, Averill, and Noyes. This has been FLA Law live on the radio. I hope you learned something tonight. If not, come back next week and we'll try it again. We'll see you next Tuesday at 5 o'clock.